hosted by K.L.E.Society's Law College, Chikkodi. Respected resource person of today's webinar is Dr. B.S. Patil, Associate Professor of Law and Director, Legal Aid Society, V.M. Salgaonkar College of Law, Goa. Sir will going to address on the topic Online Court is Antithesis to the Idea of Open Court. I will wholeheartedly welcome you, sir. Shri M.R. Sagare, Advocate and Chairman, Local Governing Body, Chikkodi, members of all the local governing body of Chikkodi, welcome you all, sir. Principals of all the law colleges of K.L.E.Society, Belgaum, welcome you, sir. IQAC Coordinator, Professor V.S. Bilgi, and Faculty Coordinator, Professor P.M. Kamte, I will welcome you both, sir. And Professor D.B. Patil, K.L.E. Law Society, K.L.E. College of Law, Chikkodi, I will welcome you, ma'am. And all the distinguished participants from different parts of the country, dear students, ladies and gentlemen, I will welcome you. Warm greetings to all. It will give me an immense pleasure to welcome you all to this National Webinar Series inaugural session. We strongly believe that the purpose of education should be to achieve the social and political goals which the country places before it. The education becomes meaningless and will have no significance if it did not train the students in this direction so as to become the noble citizens of this great country. Character transmission is the essential mission of education, and it is in this background, this college from the establishment in the year 1999 under the able leadership of Dr. Prabhakar Kore, member of Rajya Sabha and our beloved chairman, is not only imparting quality legal education to the students, but also conducting various curricular and extracurricular activities for overall development of students. Dear all, indeed, it's an honor and a great pleasure to welcome you all in this webinar series, Day 4. At the very outset, on behalf of K.L.E.Society's Law College, Chikkodi, and on my own behalf, I extend warm and affectionate welcome to Dr. B.S. Patil, Associate Professor of Law and Director, Legal Aid Society, V.M. Belgaonkar College of Law, Goa. Welcome you, sir, who has kindly consented within a short notice, despite his busy schedule, to be the resource person for this inaugural session. Sir, your virtual presence is looked with a lot of admiration by all of us, and we are all looking forward for your great inspirational words. Welcome you, sir. I accord affectionate welcome to Sir M.R. Sagare, Advocate Chairman, Local Governing Body, who has kindly consented to attend this webinar series. I welcome you all, sir. Welcome you, sir. I extend most affectionate welcome to principals and staff members of the different institutions from various regions of our great land. I welcome all the staff members of our college who always support me in all activities of the college. I also take the opportunity to welcome all the office bearers of the college union and the class representatives. Lastly, I welcome my adoring students. I once again welcome you all, sir, to this webinar series. Thank you, sir. Over to you, Anupama.
Thank you, ma'am. Now I request Professor V.S. Bilgi, ma'am, to introduce resource person of today's session. Over to you, ma'am.
Thank you, Anupama there. Am I audible?
Yes.
Okay. So good morning to all the participants and the viewers on this weekend. The resource person for today's national webinar is very actively involved in activities related to clinical legal education. Dr. Babu Gowda S. Patil, Assistant Professor of Law. He has completed his bachelor's degree in science from Karnataka University, Dharwad. He completed his graduation in law from the University Law College, Dharwad, a reputed law college in Karnataka affiliated to the Karnataka University, Dharwad. He completed his post-graduation in law with specialization in labor law from Karnataka University, Dharwad. He was conferred his doctorate by the Goa University in the year 2011 for his thesis titled Human Rights of Disabled, a Critical Socio-Legal Study in Contemporary Goa. Presently, he is serving as an assistant professor in V.M. Salgaonkar College, Miramar, Goa. He has to his credit several paper presentations at national, international and national seminars. He has also, to his credit, several articles published in reputed journals, and Sir has, to his credit, research projects sponsored by or funded by the United Nations Development Fund and the Government of India, especially in his area of interest, that is clinical legal education. His area of interest in research is ADR mechanisms, clinical legal education. He is instrumental in conducting the international competition in negotiation titled Lex Infinitum and has brought laurels to his college at the international platform. Sir is also a visiting faculty to many PG departments of law of various universities. With this brief introduction, I present to you today's resource person, Dr. Babu Gowda S. Patil. Over to you, Anupama. Thank you.
Thank you, ma'am. Now I request our today's guest of honor, Dr. B.S. Patil, Associate Professor of Law and Director, Legal Aid Society, V.M. Salgaonkar College of Law, Goa, to enlighten us. Over to you, sir.
Thank you very much. Somebody answer me. Am I audible to all?
Yes, sir. Yes, sir.
At the outset, I must thank Dr. Solapure, the principal of K.L.E. Law College, for considering me for addressing the gathering, virtual gathering. And this is my third or fourth webinar where I am making my presentation. And it has become a norm nowadays. And it would be something, it won't be a right word to say that being Sunday you all are here, because Sunday lost its importance in this era of COVID. So we are all confined to home. I hope all of you are safe at your place. The task given to me in today's discussion is about open court and online courts. It's a challenging situation, and there is an opportunity to improve the existing situation. So the topic itself is quite challenging. I want to share my screen. Please, the host, please enable me the share screening.
Yes, sir. You can share, sir. You can share.
So now the idea is, no, it is still disabled. I think you are disabled, still disabled me.
Yes, now you can share, sir.
Yes. So the topic for my today's discussion is the online court is antithesis to an idea of open court. Now, this is again a very challenging topic to deal with. The main reason is that the idea of open court is not very clear to neither to the legislatures nor to the judiciary itself, because many a times they avoid going through this the open court proceedings. So my presentation, I'm just generally, I have divided them into 4 parts. First, I'll be giving brief introduction, and here I'm talking about open court, its importance. Then I'm moving on to online court and why it was needed and why it is going to stay, whether you like it or not. And then I'm going to move on to the law on open court, the system that exists. And also in this part, I'm going to talk to another important 2 aspects. One is how India looked at open court and how it has respected the concept of open court till now. As well as I'm going to take up jurisprudential aspect of open court in various different countries. Then media and open court. Now this is something which is very, very important. Open court doesn't mean media trial. And you have to differentiate between the media trial and the open court. That's one distinction which I'm going to make in today's presentation. And finally, as a part of conclusion and suggestions, I'm looking at the path ahead. So taking up the first discussion on what is open court. Now, if you look at this open court, I know the gathering here is of varied uh, gathering with different backgrounds. There are senior lawyers, there are professors, there are teachers, as well as there are students. So I have to be relevant to all. So yeah, I may sound boring because I'm going to explain what is going on here, which you watch in a day-to-day life. So this is an open court where people are watching the proceedings. And the question here is why others should be allowed to watch the proceedings. Now, here are certain interesting and important reasons for making it mandatory for court to function in open court. First reason, fairness and unbiased. We want a judge to act with fairness and in an unbiased manner. Your case may undergo trial once in its lifetime, but judge should face the trial every day. Judge should be questioned every day to see whether he's acting fair and unbiased. It should be tested every day. That's why he should function in open court. So that's why I like to tell that the case gets tried only once, but judge faces trial every day. So that is one of the reasons why we prefer functioning in open court. The second and interesting reason is implementing or bringing an improvement in the law. So if there is a misapplication of existing law, that should be known to the people and people should question the misapplication. And if law is leading to injustice, it itself is causing injustice, then there is a need for an amendment. And these are the information which public gets, the people get in the open court system. The third and interesting point here is if you take a democratic setup, all institutions in a democratic setup are answerable to public. Legislatures face elections, executives are under the control of legislatures. So therefore, everything is answerable to public at large. The only undemocratic institution in a democratic setup is judiciary, because they are nowhere concerned with the public. They are not answerable to people. So how to make them accountable democratically? Open court is the system by which we make judiciary answerable. So to maintain the dignity of the institution, they have to function in open court and under the public gauge. Then if you look at open court as freedom of expression. Now this is something which needs to be explained. See, expression, speech and expression becomes meaningless in absence of information and transparency. So transparency and information are precursor for freedom of speech and expression. And open court ensures transparency and information. Then rule of law. That is, the rule of law is also very, very interesting requirement, because in open court, only the rule of law is possible, because the bias, unfairness, everything is kept at bay. They say the virus called corruption can be kept at bay with a sunlight. And in this case, the sunlight is the public gauge. So when the people watch, when people visit and people witness the proceedings, the unfairness, biasness, corruption, everything can be kept at bay, and we can ensure the functioning of the court in a fairness and fair manner. And the last and very important one, which is everybody agrees that justice is not only needs to be done, but manifestly seen to be done. So that is where the judiciary gains all the faith, trust, credit. What we see in India today is because of this principle which they respect. respect to the highest level. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. So this is how open court is necessary. But what happens when you go online? Now, I'm not talking about the flaws of online system, but I'm talking about the present knee-jerk reaction which judiciary has shown to the COVID challenge. The COVID brought judiciary to stand still. Rights are not being heard or protected. Violations are not being heard. So therefore, at this time, at this juncture, they need to function. And what they have adopted, what system they have adopted? The system that they have adopted is the online court. Now, what happens in online court is this. There is two parties, their representatives are sitting there on the screen. One is the plaintiff, the other one is defendant, and the judge is watching. In no way it qualifies to be open court. What I'm saying is online court, yes, it can be a part of our legal system provided it fulfills the basic requirements of open court. Only then it will be accepted as a valid development. So now there are quite a few things you should keep in mind. The one thing that you need to realize that no one can stop technology. You can maximum delay it. You cannot deny it. In the late 90s, there was a movement to computerize banks and life insurance corporation. And there was a hue and cry. There was signing campaign was going on that they don't want to do this. There will be loss of jobs and other things. What happened? They delayed the computerization by 1 or 2 years, but later it became part of it. You can look at the aggregators, that is Ola, Uber. These are aggregators, and these are the technology which are used to aggregate the taxis. There was opposition in the beginning, but now what is happening? Everybody adopted to it. So technology can never be stopped, only it can be delayed, because the benefits are so much that you cannot deny a technology. So what we need to do now is, rather than denying online court, we need to adopt online court, but at the same time, not forgetting this open court criteria. Requirement of open court is the important consideration. The second point we should always keep in mind is, whatever may be the efficiency of the system that we are having, always there is a scope for improvement. You can always improve it. So what I'm trying to tell here is that the system is in place from, say, 100 to 200 years. CPC came into existence long back, and it has faced the test of time. So it is doing very well. So does it mean that CPC doesn't need improvement? The answer is yes, it needs improvement. So if you look at the science and technology, one scientist wanted to look into the research work, and he came across with one interesting topic to do research. He chose that topic. The simple reason why he chose it was that there was no improvement in that system from last 100 years. So what happened was, he was looking into the area to do research. Then he found that the English toilet was invented to provide relief to an old-aged queen who had a knee pain. So the commode was built, and it was introduced, and it was adopted all over the world. And it happened 100 years back. Simple reason, no improvement since 100 years. So he thought there is a scope for improvement, and he started researching on that. And what he came out with finally, he invented standalone toilet. Now standalone means there is no electricity connection to it. There is no drainage connection to it. It is standing on its own with self-generated energy. And that solves all the problems of drainage system in the city. That's a great invention. and why he did it and how he did it, with a simple rule that he keeps in mind, that however efficient the system may be, always there's a scope for improvement. So then the why this debate between open and online court becomes relevant in today's world. So this all story started in 2016 or 17 when a student of law started questioning. He filed a PIL in the Supreme Court, and his simple question was, why can't you do live streaming of the court proceedings? The way the Lok Sabha, Rajya Sabha functions, why can't Supreme Court's functioning can be live streamed? The simple question he raised. And during that time, another petitioner joined, and he started asking, if live streaming is not, you're not agreeing to it, then at least you go for transcripts, the proceedings, who said what, that all let it be printed and circulated online. So when this matter was being heard by the court was very much in favor of going online. And even the Chief Justice of India volunteered, saying that his court should be the first to be telecasted online all over India. But before that could be implemented, the COVID challenge. Now, during pandemic, what happened was there was urgent need for online court proceedings, because functioning of the court became almost impossible. So they invented a system of online presentation. The Zoom, which the platform which we are using, was the platform used by the court many days in hearing the matters. We took one step forward of live streaming and making open court a real open court in real sense. We take 2 steps backward by adopting online system where it's completely purely private process. So that is where we need to tweak the technology in such a way that it is visible to all. So that is something we need to work on. That's why this debate becomes relevant in today's world. The law on open court are quite simple. First one is Article 145 of Indian Constitution prescribes open court functioning for Supreme Courts and High Courts. Similarly, Section 327 of CRPC prescribes open court functioning for all criminal cases. And in the civil cases, civil matters, 153B of CPC prescribes open court functioning. These are the basis on which open court is being adopted in Indian judicial system. This is every law has exceptions. So even this law has few exceptions. One exception is acceptable in-camera proceedings. There are certain matters which cannot be conducted in open court. Now, such processes the court adopts in-camera proceedings, like where child is involved, or a child is a victim, or child is being witnessed, or rape victim. All needs to be heard in camera to avoid further damage to the mental status of the victim. Accepted. But the second one, closed envelope court proceeding. Now this is a recent development where funnily the court asks the state to submit the details. The state denies, saying that it is in the interest of the security and sovereignty of India, the matter cannot be disclosed in the open court. Then judge asks, give me in closed envelope. The matter is submitted in closed envelope. The judge reads it and announces, we are satisfied, case dismissed. Now, is that open court functioning? So first of all, if you cannot hear the matter, don't take up that matter. Because justice is not only needs to be done, it has to be manifestly seen to be done. So that is where we are going wrong. So therefore, closed envelope court proceedings is recognized as an exception, but it is not a right way of dealing with the court proceedings. Now, how India looked into this open court system, I'll narrate 3 incidents which are very near and dear to me. The one incident is of Justice Chagla. The first Chief Justice of Bombay, and This man was junior to Muhammad Ali Jinnah, the father of nation of Pakistan. He was working as his junior in the court of law. He was offered a defense minister position in Pakistan, but he preferred to stay back in India. As a junior to Jinnah, he opposed Jinnah about the idea of two nations, and he wanted united India, and he didn't want a division of India into two nations. Justice Chagla, when he became Chief Justice of Bombay High Court, India was ruled by Congress. Jawaharlal Nehru was running the country as a prime minister. And the first ministry which was formed faced few scams. So scam is not new to India. There was a Jeep scam and there was Mundra scam. This Mundra scam was referred to Justice Chagla, and he became one-man commission to inquire into this. While conducting the inquiry, he received a letter from Prime Minister of India. And in the letter, there was a request, a simple request that we are newly formed country. This is the first ministry. We need faith and the trust of the people. Can you hold it with the minimum publicity? Because this kind of adverse publicity is going to hamper, or it is going to adversely impact the reputation of the state. So he received a letter, and next day he went to conduct the inquiry, and he saw that the court hall was jam-packed. Everybody were sitting there waiting for the proceedings to start. Justice Chagla called the commissioner and asked him to change the venue. He didn't want to conduct here. So he moved from open court to open ground. He hired public address system, and he started conducting the proceedings in a Brabon football stadium. The whole proceedings was held in the open ground in front of public gauge. Public witnessed it. Every day there was increase in number of people observing the proceedings. And that's how Justice Chagla lived by the example, saying that open court is the lifeline of the judiciary. Second example is of another prime minister. When Indira Gandhi was assassinated, the matter was before the court. The assassins K.L.E. and Satwant Singh were tried in the court. Between these two, from 1950s to 1980s, in that gap, there were quite a few judgments on open court. And the way Justice Chagla respected open court, the same respect was not given by the other officers of the court. In this matter, K.L.E. and Satwant Singh matter, the executive decided to hold the proceedings inside the Tihar jail. The reason they gave is that the matter is too sensitive and it is too risky to bring them out of the jail and face a trial and bring them back to jail. The transit is going to be very risky. So they don't want to take that risk, shift the court to slowly, there is a disrespect. Hello, can you hear me?
Yes, sir. Yes, sir. Yes, sir.
Suddenly it got cut.
Yes, sir. You can proceed, sir. Continue, sir.
Yeah. Thank you. So now Sahara India Parivar is another matter to be taken into consideration. Now in this case, what happened was, this was in 2000, this decade itself. I think it is 11 or 12. During that time, Subrata Roy gave a wrong information to the court about distribution, or filed a wrong affidavit, and the court was very, very upset with that. And they passed a very harsh ruling against him. And that ruling was being questioned, and it is being heard in the court. The next day, they received an application. The court received an application from Subrata Roy, and his application said that there is a lot of adverse publicity against Sahara India Parivar, and therefore the share value is crashing, and we are suffering huge loss. So therefore, the proceedings before the Supreme Court should not be published. It should not go to media. They are not asking for private hearing. They are okay with the open hearing, but it should not be published in the newspaper. So that's the request they made. Now this is again, here comes the difference between open court functioning and media involvement in a trial. So here the court said that we will function in open, but we can delay the publication in the newspaper. So there was a deferred publication of the court proceedings. So again, this is how the whole growth of open court system that existed in India. Now going to the next point on jurisprudence, reasoning, and open court worldwide. Now, if you look at this jurisprudential requirement, every country looks at open court from a different angle. USA agrees for open court and they respect open court, but the reason is it is part of their freedom of speech and expression. So they are for transparency, information, so that expression and speech can be protected. Similarly, the European Union believes in open court, not for freedom of speech and expression, but to protect the presumption of innocence of the accused. So they ask the society to closely observe the proceedings and ensure that the presumption of innocence is protected under all circumstances. The United Kingdom, we are very closely associated with UK when it comes to jurisprudence of open court. They believe protecting justice is the paramount consideration, and it can be done only by allowing open court functioning. So they look at justice as the requirement. Similarly, the next country, that is Canada. Canada looks at balancing between freedom, like USA, and justice like UK. So they bring a balance between justice and freedom. And that's how they recognize the open court as a requirement. Australia, they allow open court functioning, but there is a clear-cut ban on publication. So they don't want media to be involved with the court proceedings, but they allow open court functioning. And the best approach, which I do see, the best approach is of New Zealand. New Zealand respects open court, and they say open justice approach is the only way a court can function. It's always open justice approach. So they are not ready to create any kind of exceptions to the rule, and they want to adopt open justice approach as the best way to deal with the open court functioning. Now the question before us is why court and media can't go hand in hand? Why there is so much of fear against media functioning? The simple reason, I will discuss this with three important points. First, very important point that should be kept in mind is justice is not a commodity. Media treats every information as a commodity. They look at selling the information, gaining the TRP, gaining the circulation, and improving their business. So once the justice gets commodified, then there is a danger of miscarriage of justice. So how do I come to this conclusion that it's commodified? The reason is only crime is highlighted in the court. Have you ever come across with a case where the media discusses that somebody is fighting for their labor rights, somebody is fighting for their consumer rights? These rights are equally important, but no media house discusses this. No print media discusses this because they cannot be commodified easily. Crime can be made into commodity easily. So therefore, the court and media cannot go hand in hand. And a very important reason, the last but not the least, entertainment does not create a proper perspective which education can create. Court believes in open system provided you are there to get educated. If you are converting that proceedings into an entertainment, then you are not welcome, because entertainment doesn't give you a correct perspective what an education can create. So that is the reason why there is a kind of a disconnect between court and media. Now, open court is going to be given new meaning. Now, this is my perspective of open court. Now, we are seeing that court functions in an open court. But is it open enough? Or something else needs to be done? I'm going back to what I started with, saying that there is always scope for improvement. Now, how does a court restricts spreading of information? There are three methods. Controlling of information can be done, number one, by holding in-camera proceedings without allowing anybody to come in the hearing process. Second, and it is most commonly used, restricting the access to documents. Now, this is an area where law is not very clear. This is the area where we are not thought much about. That is giving access to the document. I'm talking about access to non-parties to the documents. I'm not involved with the case, but I want to read the case papers. But whether I should be given access to it. Now that's the question which needs to be answered. Restricting the publication of the proceedings is another way they control the information. And we need to release this information controlling from all three aspects. The last third one, we may wait till our media becomes responsible, but the first two are very important. Function in open court. Second one is give access to documents. Giving access to documents invites much more complications. Those complications I'm going to discuss now. Now, when we look into the document, access to documents, now again, transparency and right to information ensures freedom of speech and expression. Now, access to document is one way of ensuring freedom of expression. So that's why access to the documents has to be given. Now, similarly, the freedom to receive information is the right of a common man. I am not involved with the case, but I have a freedom to receive the information. So here comes the conflict between two rights. There is a right to privacy, where a person doesn't want to reveal his case papers to anybody else, but there is a right of freedom to receive information, right of transparency. Both are equal rights. There cannot be any hierarchy of rights. Under these circumstances, how do you deal with this? All are equal. One cannot take precedence over the other. So what is the way forward? The way forward is give the right to decide to the judiciary, because it all depends upon the factual matrix. And case to case basis, fact to fact basis, the whole matter to be taken into consideration. That is why the right to access to documents should be decided by the court itself. But access to documents should be given as one of an important requirement. Now, what is the path ahead? How we are going to go ahead with this? The first thing is online is not antithesis to open court. Online should be accepted and open court should be respected. So acceptance and respect both should go hand in hand. If we adopt online but doesn't respect open court, that's not the way forward. Present knee-jerk reaction to COVID situation is antithesis to open court because there's nothing open in that whole functioning. Everything is being functioned in an opaque manner. Now, there is a need for improvement over the system. So COVID has given us a chance to adopt a new process. So what we need to do is we need to nurture it and improve it. And online, why I'm for online and why I'm favoring online is because justice to the doorstep is the dream of independent India, and it could never be achieved till today. No matter how much the legal service authorities are working and how much of money is pumped in, there is we have not achieved justice to the doorstep of needy, but online can do it. 1% of Indian population utilize Supreme Court of India. 3% of Indian population use the high courts of India. Now that's the level of access we have today. But if you go online, then the cost of travel would reduce, the cost of advocates would reduce. So there would be a lot of benefits to the general public. So justice to the doorstep can be reality if online is accepted and respected. Live telecasting should become norm in near future because we should not adopt this system during COVID and go back to the normalization. Advocate Manu Singhvi, Abhishek Manu Singhvi, the congressman, is a vehement supporter of live telecasting. He believes that this is going to solve all backlog problems, the docket problem, because the court can function more efficiently with this live telecasting and online submissions, online petition making. So once you go online, things goes faster. During the discussions, I mentioned that from Justice Chagla to Indira Gandhi case, there is a deterioration of open court system. And one of the reasons why it got deteriorated is because of the attitude towards open court. Many judges, including Justice Hidayatullah, were of the firm opinion that open court is a mere procedure. It's not a substantive right. And they rightly so, they say that procedure is servant of justice and not master. And if the procedure can lead to an injustice, then the procedure can be circumvented and justice should be protected. So they strongly believe that procedure is, the open court is a procedure and the procedure is servant and not the master of justice. But the recent developments like the RTI, Right to Information Act, the right to transparency, right to information, all these legislations has changed open court from a procedure to a substantive right. Because now open court is one of the requirement of transparency. Even today, Supreme Court is strongly denying access to their records under right to information, which is again wrong, I feel, because they should be open as any other court in India. They are not something different. They are not above the law. So what rules India? It's the law which rules India. So similarly, going ahead with other discussion, document access to non-parties is one of the important requirements. As I mentioned, you need to balance between the two important rights, right to privacy and right to transparency. So avoiding commodification of justice is another very important requirement, and court is doing it very well as far as commodification is concerned, because that's why the gag orders are passed against the print media as well as the other medias. But presently, when you look into the functioning of print media or electronic media, what I see is there is a lot of media trial going on, and it is one way or the other influences the judicial functioning. And that is where we need to come back strongly against media trial. So this I already mentioned, balancing the privacy and right to transparency is another very important requirement. So with this, I'm coming to end of my discussion. Thank you very much for opportunity given. I hope it was quite useful for you all. And I feel that this opportunity that you are given, I utilized it very well, and the people who have joined me are happy with the whole proceedings. Thank you very much.
Thank you
Thank
so
you,
much, sir.
sir.
Now I request Professor D.B. Solapure, Principal K.L.E. Society's Law College, Chikkodi, to moderate the session. Over to you, sir.
Thank you, Anupama. Respected sir, thank you for the wonderful discussion. And as we know, online court proceeding is become a new normal nowadays due to COVID-19. The same has been explained by you with the live examples, and indeed you said that online should be accepted and open court should be respected. With these words, I would like to take some questions, sir. Those have been asked by the participants during the registration forms. The first question is raised by Mr. Raman Sharma, Department of Law, Punjab University, Chandigarh. Sir, his question is, what is the future of ODR, that is online dispute resolution, in developing country?
ODR. See, online dispute resolution is much wider concept than open court or online court, what we are talking about. ODR talks about online arbitration, online mediation, etc. And I feel that ODR, when you use the word ODR, it is mainly concerned with other dispute resolution systems other than the court. Now, when you talk about the feasibility and future of ODR in India, what I feel is, first, the physical dispute resolution should come into picture, come into existence. Presently, we are not doing very well with alternative dispute resolution systems. Rarely we resolve cases through the alternative systems, and courts are, even today, they are getting burdened. CPC has been amended. There has been a lot of pressure on advocates to settle the dispute, but still many don't agree with resolving the dispute through ADR system. Now, ODR, it's a far-fetched dream. First thing we should keep in mind is the technology and connectivity that we should be enjoying. But ODR definitely can be a very important and useful tool for online disputes like online purchases and other things that can be dealt with ODR. But in near future, I don't think it is going to gain any momentum. It's going to take time. Yeah, thank you.
Yes, thank you, sir. Thank you. There's one more question from Professor Murlidhara K., Soundarya College of Law. The question is, how to reach to the common people through online court?
Yeah, during my presentation, I mentioned that online court brings justice to the doorstep. How common man can do it? It's not the common man which should do it. It's the government which should do it. So government should create facilities at village level. Now, what I have seen is now the government has gone to the village level when it comes to making an applications, Aadhaar cards and other things. They can do it in their village itself. So online reach is already been established by the executive. Now it is only that government should ensure that people from their village can file a petition and they can be heard from their own places. It's the government's job.
Yes, thank you, sir. Good afternoon, sir.
Good afternoon to you. Good afternoon to you. Yes, thanks, Principal sir, for permitting me the screen. And thank you very much, Babu Gada Patil, for the very interesting presentation. And primarily, I requested to share the screen to thank you for coming platform and doing this great job for us. On behalf of Executive Committee of K.L.E. Society for Law Colleges, I thank you profusely. It was a wonderful presentation indeed. And there was, of course, the second reason why I had to come on screen. Uh, as we share this passion of discussing on these very interesting conundrum kind of questions. Of course, a lot of what was bothering in my mind, you have in fact covered in the course of your talk. I was really wondering, when I pose this question, it's not that I'm against open court system. Open court system is the way in order to make sure that the justice is seen to be done. As we all know, justice must not only be done, it must be seen to be done. Open court system is the way. There is no doubt about it. And as you rightly said, of course, you put it very strongly that a judge shall face the trial every day, and he does. It would have been nice in our system if the judge faces the public trial. Unfortunately, judge is not facing public trial, judge is facing media trial. Very unfortunately, such a bizarre thing has happened very recently in Karnataka High Court. Without naming the particulars, if I may quickly tell you what has happened. In a rape case, the judge, presiding judge, had to make a comment. Like, a particular conduct of victim was unworthy of being Indian women kind of thing. Maybe I'm not. Let's not be judgmental on what was said, whether right or wrong. Why should it be made such a big issue, bringing a lot of pressure upon the judge? If the judge has made that observation, whether he based that observation to make his decision or not, that has to be verified actually. If he has not made that the basis for his judgment, probably it is for the higher courts to review his conduct, his decision, etc. Such a bad thing, in my view, that has happened was such a pressure has been brought on the judge, and that judge and other judges would definitely come under pressure, and independence of judiciary and free thinking, free rationalizing is at risk, I believe. I just wanted your responses on this. Thank you.
Yeah, that's a very serious issue. What you said is very true. Public trial is different from media trial, and that's what I have been telling throughout my presentation. And the incident that you narrated, it's a very serious one. If somebody expresses an opinion, and that opinion is only a personal opinion and doesn't influence his judging,
Yeah.
it should not affect anybody. So what is happening here is, again, I'm talking about commodification of the whole process. They are making into a commodity and selling it to the people. Contrary to your experience, I personally observed a proceedings where two persons, in fact, three people were accused of raping. And she happens to be a professional, a prostitute, and she was arrested along with these three fellows who are accused of raping her. And then the case was filed, and she shifted from that village town, and she went somewhere else and continued the profession. Now these three fellows are facing the trial. In absence of the complainant, knowing fully well that she is a professional, judge convicted all three, because judge strongly believed that no is no, no matter what person is, because every person has a right to decide. So that I felt the judge, many, even the many locals, media felt the judge was too harsh on them, because it is, we are living in India. By the time when they were arrested, they were teenagers, but by the time when they were convicted, they were married and having two children, all of them. So the judge went ahead and convicted them. That's the daring the judge showed no mercy. He did not allow his personal feelings to influence the judging. So that's what is expected from the judge. And he actually won the public trial, but he did not win the votes from the media. He did not win the votes. But being the legal people belonging to the legal fraternity, we must appreciate the way the judge conducted himself.
Yeah.
So the point is very true that public trial is very needed, but not this media trial. See, you cannot build a pressure on a person. You can do it after the judgment, because always there is a provision for appeal. So wait, go in appeal. Why you decide that this is going to influence him? This is prejudging the whole process.
Thank you.
Thank you.
Thank you once again.
Yeah.
Thank you, sir. Thank you, sir.
Over to you. Over to you. Please take it forward.
Thank you so much, sir. Thank you so much. So the next question is from Jay Mani Trivedi from Institute of Legal Studies, CSJM University Campus, Kanpur. Sir, his question is there a privacy and confidentiality arrangement available to run online court?
The privacy, confidentiality should not be a part of a judicial process. Yeah, it should be open. And in online court, why I'm against the present COVID style of court functioning is because they are all private. Public access is not there.
Yes.
The Zoom, the way we are using this platform, the address is, link is sent to the plaintiff and the defendant, and judge hears both of them. So there is no public view. So confidentiality and secrecy is necessary in some cases where serious crime is involved, where offense against women is involved. But that's only few cases. But large chunk of cases, maybe 99% of cases, it should be open. Yes.
Thank you, sir. Thank you, sir. So the next question is from Mr. Uday Sannaki, who is our student, sir. His question is how online courts are beneficial in case of criminal trials. And he explained the question in two parts. The first one is when there is a grave chance for accused to escape from further proceedings. And secondly, deep fake simulations and artificial intelligence are already implemented into the internet systems. Then, what precaution do the judiciary have to prevent such deep fake simulation?
But deep fake simulations and these risks are always there with the internet usage. While presentation going on, I have seen some of them are scratching the screen with the scratch came on the screen. Yes. So these things do happen because it's a new thing. See, always remember there is a transition. There is a stage, transition stage, and then final stage. Just an example where when the road is being built, the locality is going to suffer a lot because of all the dust that it's going to create. But once the road construction is over, they are going to enjoy the smooth running of the vehicles. So we are in a transition stage. So when it comes to deep fake and other risks with internet, they do exist. And how to handle it? It is we can only give the precautions that we need, and these precautions has to be built by the technologists. So here, the law and the technology is going to interact and come up with a system where it becomes foolproof. Now, when it comes to criminal trial, now how far it is beneficial for a criminal trial? Now, presently, Delhi is using this online thing quite a lot when it comes to chief examination and cross-examination. Many times, the accused is kept in the jail and he is connected through Wi-Fi or through internet, and the discussion goes on through internet. These do happen, but not on a regular basis. In exceptional cases, they take up these things. Now, important thing in a criminal proceedings. See, there are two things we should keep in mind. A trial is very different from hearing. Supreme Court and High Court, what it does is very different from what trial court does. In the trial court, a judge has to be very careful with the demeanor of the witness and the behavior of the accused, whether he was sweating, his palms were sweating, he was answering fluently, whether he was looking around. And sometimes even judge go to the extent of sending the police out of the court hall just to make the witness feel safe and ask the questions. So there are a lot of things which judge must ensure, and which is not possible in an online process. In online process, what happens is judge visibility is restricted by the camera's focus. So
Yes, sir.
now you can see that green background of mine, that's the focus you are having. And next to me, somebody must be holding gun and standing and telling me to explain the way he wanted. How do judge ensures that? So that is where the criminal trial, we need to be very slow and sure about the process. We need to be we should tread the path very carefully. Thank you.
Yes, sir. Thank you, sir. Thank you so much. Sir, the next question is from Ms. Mumtaz Nada from K.L.E. Society's Law College, Chikkodi. Her question is, which is the most effective system in the administration of justice, whether open courts or virtual courts? Isn't virtual court contrary to Article 145 Clause 4 of Constitution of the India, Section 327 of CRPC, and Section 153B of Civil Procedure Code?
So the question is whether it's violates
contrary to those provisions, sir. Yes, sir.
I think this is the title of the presentation, actually.
Yes, yes, sir.
My answer to this question is they are not. But the present system, definitely yes. Yeah. The COVID system, they are in violation of all the three legislations: Constitution, CRPC, and CPC. We need to build some other process, some other, we should make some technological improvement to make it open court. But one appeal to all listeners is that open court should be respected under all circumstances. Otherwise, the judiciary loses its credibility. Yeah.
Yes, sir. Sir, there is another question from Dr. J.S. Halshetty, Advocate, High Court of Karnataka, Bengaluru. Online court is like online marriage. You can't conduct trial online. Importance of cross-examination is lost. Witness can be tutored easily online. What is your opinion, sir, on this?
My opinion is online marriage can be successful, but not online trial. Yes. Because now the technology, right. IVF, other things are there. You can be successful with online marriage. But what happens is with yes, the trial, the technology has not improved that much. So Hal Shetty I think he didn't wanted an answer for this. Thank you.
Yes, sir. Yes, sir. Thank you, sir. Sir, one more question from MD Danish Alam from USBM Bhubaneswar. His question is, what about potential violations of rules relating to multi-jurisdictional practice of law?
Multi-jurisdiction is a problem because we have tribunalization of justice that's yes. happening in India. We are building tribunal. We pass a law, and under the law we have a tribunal, and tribunal is going to handle the matter. So with many tribunals overlapping with the court, there is a multi-jurisdictional things are coming up. Now, if court goes online and tribunals remain offline, then there can be a conflict. But in most of the litigations, in almost all the litigations, there are two parties. Whenever there's a yes. utilization of multi-jurisdiction is there, the party which is going to suffer will always bring it to the notice of the court and ask the court to suspend the proceedings. That's what happens under Section 10 of CPC, res sub judice. So the request for suspension is made. So partial online by judiciary, tribunals are remain offline. These are going to cause a little bit of problems. And that's a very good, that's an important observation, and it should be kept in mind whenever we go for online.
Exactly, sir. Exactly, sir. So there is one more question from R. Vidya Bharti, Chennai High Court. His question is, while recording evidence, I think there will be undue influence or threats to the witness. The judge may not be in a position to understand whether a witness undergone going threat or undue influence at the time of recording the evidence of witness. Whether it can be monitored, as you already answered this
Yeah,
question, sir.
yeah. I have covered.
If you wanted to.
Yeah, as I already covered it,
Yes.
it's a trial process
Yes,
is
sir.
very different from hearings. I think hearings should be done
Yes.
online. We can go online now with hearings.
Yes.
Trial,
Yes.
yes, still we need to go offline.
Yes, sir. Sir, there is one more question from Miss Anupama Bolas of our college. Her question is: are virtual courts able to cope with huge backlogs of pendency of cases?
These are online courts.
Yes, sir.
Yeah.
Whether they
Yes,
are cope up with
definitely.
a huge backlog.
Yeah,
Yes, sir.
actually what happens is online courts are going to increase litigation. That's my understanding
Yes.
is that once you go online, once justice reaches your doorstep, you tend to file more and more cases. So it is not only it's an answer for existing docket, existing workload, it's going to increase your workload. Nowadays we are going for various other methods to resolve dispute, but when the justice is at doorstep, when the court is available on our fingertips, we will definitely go to court. So it's going to increase the workload, and it definitely it will make the court more efficient.
Yes, sir. Yes. Thank you, sir. You answered all the questions wonderfully. Thank you once again, sir.
Yeah.
Now over to Anupama.
Thank you.
Thank you. Thank you, sir. Now I request Professor P.M. Kamte sir to propose vote of thanks. Over to you, sir.
Unmute button.
It gives me immense pleasure to propose vote of thanks this afternoon. Myself, P.M. Kamte, K.L.E.Society's Law College K.O.D. First of all, I would like to propose 30 vote of thanks to our today's resource person, Dr. B.S. Patil sir, Associate Professor of Law and Director, Legal Aid Society, P.M. Salgaonkar College of Law, Goa, for gracing today's webinar. Thank you, sir, for your very interesting and thought-provoking address. I would also like to thank to K.L.E. Board of Management and members of Executive Body for law colleges. I would also like to express our profound gratitude to Professor D.B. Solapre, Principal K.L.E. Society's Law College Chikodi. Thank you, sir, for your unending support and effort. I would also like to thank principals of all colleges. And I would also like to thank Professor P.S. Pilgi, IQAC Coordinator, K.L.E. Society's Law College, Chikodi. Thank you, Madam. I would also like to thank Professor Deepali B. Patil, K.L.E. Society's Law College, Chikodi. And also, I would also like to thank Professor Lata Sardar Madam. And I would also like to thank J.M. Mallikarjunaya sir, Principal, K.L.E. Society's Law College, Bangalore. And I am happy to express vote of thanks to our staff members who have made this webinar a grand success. Finally, the wonderful participants and students who have turned up in such great numbers, not only from our state, but also from throughout the country. Thank you so much for your cooperation. Once again, I thank all for your cordial cooperation. Thank you. Thank you, one and all. Jai Hind, Jai Karnataka.
Thank you so much, sir. Thank you all.
Thank you, sir.
Thank you, sir. Thank you.
Thank you.
Thank you, sir. Thank you.
Yes, thank you, sir. Thank you so
Thank you,
much.
sir. Thank you.
Yes.
Thank you, sir.
Thank you, sir.
Sir.
Thank you,
Thank
sir.
you, sir.